Wish you all a very happy Dhanteras. This is the day of getting and preserving the dhan that you already have. And we all know that as Indians, we are very good at this. The whole economy around the world, or the very fact that for years together we have had the savings to walk us through various parts of life, gives everyone a very clear idea that we have been pretty conserving, and at the same time growing, and at this point in time, a very prospering economy. At this particular stage in the growth of this country, it's all about the next phase and the next phase and the phase beyond. We all are growing, and we are growing at an accelerated stage. And when it comes to MSMEs, particularly this growth means a lot, and quite a few times it gets triggered by a very specific set of clients or companies with whom we are working. And the relationship here is all about the trust. We all believe that as MSMEs, there's a kind of unwritten agreement between us and the OEM with whom we are working. And we work a lot on that particular part, which is what we believe as a trust, the rapport or the word. उन्होंने जबान दी है, उन्होंने बोला है तो होगा. And in this kind of an environment, I want to bring a very different perspective today, which is about conserving this wealth by getting your contracts right. It's an absolute privilege for me to have Alhad joining us for this conversation. Alhad, thank you so much for your time, and wish you and your team a happy Dhanteras.
Thank you, Charu. Thank you for this opportunity, and really privileged to be with you on this Thinkly platform. I will be happy to contribute in whatever knowledge I can share with the team, and it will be really a pleasure to be with you on this show.
Alhad, I would first like to understand what has been your journey so far.
Journey?
Yes.
Yeah. So journey is quite interesting. By profession, I'm lawyer, company secretary, and by qualification, I'm qualified as a chartered secretary and administrator in London as well. I worked in corporate world for 12 years, and then had a calling one day that, okay, let me get started with something of my own. And 2008, that's how I started my own firm called YNZ Legal, and that stands for Young and Zealous. Don't go by my little bit gray hairs. I'm still young, and my team is zealous. So Young and Zealous is all about that. So we are having just fun working with team, advising clients, and doing fantastic work for the team as such.
Amazing. So Alhad, I would get away straight to the point. In MSMEs, a lot of the entrepreneurs believe in this thing called trust, because that's how the businesses have grown over a period of time. And that's why we don't really believe much in contracts and all. We all believe that it's a cost. So how can you help us understand as to how do we start seeing contracts as a necessity?
So whenever this trust factor comes, I always remember one movie called Main Hoon Na. So a lot of people, they start working with procurement team, admin team, HR team, and they say, sir, ek proposal bheja hai, please approve karke bhej do. And the guy who is an authority and power, and he says, arey main hoon na. And then you never know that when this main hoon na goes away from his space and place and seat of authority, and the next guy comes and the question asks, who are you? No, I don't know. You may be having certain understanding, but where is the kagaj? Kagaj kahan pe? So kagaj ke fool, and the person who is believing on that trust, he becomes the fool because he does not have any kagaj along with him. So that's the problem. The guy has reposed his faith on other person, but forgot to prepare documentation, not even by email, but just on the oral conversation. And you have nothing to prove whatever you say, because other people will only go by the paper.
Absolutely. Now this idea, I believe a lot happens because of the way the business was transacted for long. But when a company gets incorporated today, where we should start? Can you walk us through the journey of how, right from the startup till, particularly at the startup and the growth phase, how the companies need to protect themselves by getting into the right agreements?
Sure. So what I would say here right at the initial stage, so typically the kind of scenario that we are looking at nowadays is that industry experts who have worked with different organizations, multinationals, and they want to start their own firm, company, or any kind of organization. There could be other kind of people who have zero experience, and right after the college, or even in during the college phase, they are starting their own firm or company. And there is a tremendous zeal to work, but the essential element is that as a partner, when you come together, so working with friends is different story, but working with friends as a business partner is a completely different understanding. And that's where we are, as Indians, we are very emotional, and we don't talk about the negative things. And so we all say that, okay, things अच्छे रहेंगे, बढ़िया रहेंगे, we will do great things and blah blah blah. But then we don't even think about that if we have to exit for some reason. Maybe it's a family reason, maybe it's a financial reason, maybe it's a medical reason, or any reason. Generally, मेरा बनता नहीं है, मेरा पट्टा नहीं है, whatever. Even these kind of small thoughts also. But then, what do we agree on some common ground? Then it could be MOU, it could be a founders agreement. Then if it's a larger venture, it could be a joint venture agreement. But before incorporation of a company, the partners or promoters who come together, they should ask them fundamental questions. Number one, am I committed to this business? Am I committed to this business only financially? Am I committed to this business with financially, operationally as well? Or am I only contributing to the profits of the business? So these are the very fundamental questions which needs to be answered right at the initial stage. And we as partners should not be shy about it. We should talk that right upfront with the other promoters, and then get it documented. Whatever way you want to get it documented, please get it documented by way of MOU or founders agreement, and then go ahead with the incorporation of a company. And again, for incorporation of a company, in the sense, you can have different forms. You can have a partnership firm, you can have LLP, you can have a private limited company, public limited company, or in some cases, you are doing some social cause. You may have a Section 8 company or trust as well. But identification of proper medium or entity is very, very critical. So that's my suggestion. Right at the initial stage, people should try it out on the basis of an MOU. Try out 6 months, whether it's working, not working. You have a good wavelength matching or not matching, and then go ahead with the incorporation of company or whatever venture you intend to do.
Agreed. The other, when we start getting into the business, what happens is, a lot of times people come in, and particularly it happens for the startups, that आप कर लीजिए काम, हम आपको बताते हैं, and then there are some very not so well documented, and a lot of discussions happen in even on the client side in good faith to give some business to that particular startup. But when it comes to the actual realization and the invoicing, it doesn't happen. So a lot of time, particularly even asking for a thing as simple as a purchase order is an issue, right? Yes. So how can the startup get into that mindset of getting into the contracts? What would you guide them?
So I would suggest that when you initially provide a proposal, okay, make that proposal as a pseudo agreement itself. So put certain important terms and conditions in the proposal, okay. And those, because what happens, sequence of events, typically what happens is, I have created a proposal, I have given it to the client has discussed, negotiated, and closed it. And directly what I get is a PO. And the PO and the proposal does not have any link over there. But last document is PO, and PO doesn't refer to my specific terms and conditions. And I have agreed on the basis of PO, which means I have agreed to the PO terms and conditions, and I've gone ahead with the activity. And that's where the issue happens. So ideally, what the promoter should do, that they should have a proposal form including certain terms and conditions. And when the PO is accepted, okay, along with PO, the promoters or the MSME should give an acceptance letter to the client that the PO is accepted with specific conditions which are there in the proposal, and we consider those conditions are incorporated as part of the PO conditions. For example, if my PO condition is, say, 15 days payment cycle, the standard PO of client has 45 days payment cycle, then there is a discrepancy. if my PO conditions refer to that in case you do not pay me, I have a right to suspend terms and conditions. But naturally, when the PO comes from the client, they will not have this kind of condition. So those conditions which are very critical to your business related aspects, you need to again go back to the client by way of an acceptance letter, or again some sort of communication which makes sure that you are agreeing to that PO with respect to certain terms and conditions. So the mindset of the MSME should be that the document, when I create a document, it is going to help me in future, whether it's a dispute or no dispute. But it is a document that I can rely on. It's a very helpful document to me.
Agree. The one of the factor that MSMEs actually use is a lot of MSME promoters tend to play in the gray area, right? So things like escalations, things going here and there, sometimes going more, requesting, adjusting, avoiding the LDs and all, right? These are the things that people believe that playing in that gray works far better rather than having the clarity. So can you give us some examples regarding how this playing in the gray creates issues?
Yeah, so one of the classical example of playing in the gray is about the sales related commission. Okay, this is an area which I love and I always debate with the promoters, that consider a situation that I am a referral partner. Okay, and I have a referral partner and I'm supposed to get my referral commission once the client achieves the business. Okay, now here is the catch. Now I'm referring to a client and a partner or a prospective client from my perspective, who's already working with that client. Now what happens, client would come back and say that, okay, that other party is already my client, why should I pay commission to you? But this is a gray area which is not clarified. Okay, that, okay, for example, just for the sake of example, I am naming some certain companies, that, okay, L&T kind of company, or it could be a buyer, for example, or HCL kind of company. There are so many divisions. So one division may not be aware about that you are working with another division. So for one client may not be applicable for all the clients, but then that clarity should be brought in during, but people play around with that gray area, and that's where the dispute happens. Because when I go for a commission, they say, no, they are already my client. And this was never clarified.
True. The one very interesting question here, Alhad, is that we have got a lot of tools which are available, which offer you a lot of legal documentation, right? Saying that you go and go this particular contract. So what is the point in time till when the MSME can work on those particular platforms, and what point in time they should actually be consulting with the lawyers?
See, it's always good to gather certain knowledge from the public domain, for sure. And they can always get certain ready-made templates as well. It's always nice to have these kind of templates as a starting point. It's always good to have it. But every time when you get a template is created in a generic manner. That one has to understand that a generic manner template is addressing only the generic issues. Now, if I am a specific related, now if I am dealing into a chemical related business, now a generic template which is related to a plastic granules related products is not applicable to me as a chemical industry. Because if I am into a hazardous chemical and I am into some chemical which needs additional precautions, those kind of precautions are required to be incorporated in the document. Because whenever I do my business, I need to analyze my business in three factors. One is about the financial risk, second is about the operational risk, and third is about the reputational risk also. So these are the three elements which should be considered, that what kind of financial risks which are there in that kind of transaction. What are the operational risks? Now, for example, in terms of medicines, or in terms of molecules or drugs related aspects, you need to preserve those material at a certain humidity and certain temperature. If that humidity and temperature is not maintained, the entire quality of the product which I'm going to supply is going to get deteriorated, or it can work in the reverse function also. It can be even poisonous as well, because the material specifications are not met. But then if I download certain templates from a generic template, it may not have those kind of specific conditions, because those specific conditions are very unique to my product. And that's where it's always good to have those kind of templates, or from platforms you can get all the information. But again, apply your business logic, your business mind and operational mind to it. Identify financial risk, identify your goodwill risk also, and then put it over there so it could be a good combination of both.
The next phase naturally goes for MSME Alhad is the growth bit. And growth is the phase wherein companies start looking at either geographical reach, or they start looking at new layer of businesses or allied businesses compared to what they are doing. And at this point in time, how the contracts can help MSMEs protect their interest?
So that's a very important question, because typically when, as you rightly mentioned, that somebody wants to grow in different geography. So for example, now if there's a MSME who wants to develop a business in, say, African countries, or they want to get into Asia Pacific region. Okay, so typically the first point of contact is somebody who is a channel partner or distributor, or somebody who's ready to do business for and on my behalf in that country, because the kind of advantage that the person has mentioned is about that I am the local person. I know how things work locally in terms of routine business practices, in terms of government and regulations, and the people mindset also. And that's where when you have to go for this kind of relationship, don't put the entire relationship at risk, because you need to go slowly and steadily. Don't give an exclusivity for a 3 years period of time right upfront at the initial stage, because the person would say that, look, if I don't get exclusivity, I will be spending so much of amount for your development of brand, blah blah blah. But then for me, if you don't do anything, I will be locked out of that country for those 3 years period. So you can have, for example, exclusivity for a 6 months period, or exclusivity only for 1 year period, that if you don't perform within that 6 months or 1 year period of time, the exclusivity goes away. So those kind of conditions could be utilized to your benefit, so that you work along with the person, use carrot and stick model, that, okay, I am giving you this carrot, okay, that exclusivity is granted to you. But if you don't perform in 1 year's period of time, which is a logical period, then the carrot goes away. And that's the stick, that the exclusivity will not be there. I will be able to appoint other partners as well. So those kind of things should be identified. Right at the initial stage, you need to identify what are the commissions involved, what are the manpower related challenges, whether you are required to incorporate a separate company over there. Can you do a business in that entity, in that country? Because there could be certain countries which are restricted from the regulations perspective, maybe India regulations perspective, world regulations perspective. So you need to be very sure about what kind of countries you are engaging with, and accordingly do the documentation for that.
Agree. This takes the company to the next level, wherein the company now starts talking about some kind of merger or some kind of acquisition, right? At this stage, a lot of these things happen. Usually, it's very easy to find somebody who you believe that you can go and acquire. Probably this makes a lot of sense. But at this time in time, the due diligence that we call for, right?
Yes.
So how does a company should go about looking at it from a legal perspective?
Right. So I'll split this question in two. One is about a formation of a JV kind of situation, where two partners coming together, creating a new incorporation of a company and doing business in that newly incorporated company. That's a typical JV scenario, where as an Indian MSME, I have either technology, which I'm going to get extend to the other partner, or I have a manpower or skills that I'm going to extend to other other party. Other party is a local party, or it can happen in other way also. That, for example, a German company is coming into India with their technology, with their kind of research and development, and they have a product which is ready out there and which needs customization as per the Indian requirements. And now I am in India. I can help them to customize it to the Indian market. I can market it in India, and I'm a JV partner. In both these scenarios, you can form a SPV, which is a special purpose vehicle, which is like a joint venture company. And then you can have relevant terms and conditions agreed about it. that what kind of board one company will have, where your representation, my representation, what kind of rights I have, how do we control overall operations of the organization? Do I have a right to appoint a CFO or CEO or something like that? So that's one part. Second part is about the acquisition or merger that you mentioned about it. So in this case, for acquisition, I can share that now I look at a business which I have been dealing with them for a while. Now I have understood that that business is either a good compatible business to me, or it's exactly the same what I do, and then there is a lot of synergy and acquisition is possible. Now, a lot of time people have a misconception that acquisition is just acquisition of a shares or acquisition of a stake. But rather than, I would say that there is a huge impact in terms of culture, because culture of my organization, culture of other organization may not gel at all. And that's very, very critical. So due diligence, although you can have a due diligence with respect to the finance, taxation, legal, corporate secretarial, other compliances, litigation, but this compliance should also be done in terms of due diligence of what is the culture of my organization and what is the culture of the other organization. Now the other parts will come into picture, the structuring of the deal. Now, do I get into the company directly right at the 100% acquisition mode, or I'll be acquiring the controlling stake 51% or 76%, and they gradually I grow, I buy out the promoters from there, and then I get a 100% acquisition of the organization. So those kind of things will emerge at a later date. But initially, when the financial and other due diligence is happening, this culture related due diligence and culture fit should also be checked. Manpower, what kind of people I have, what kind of people other organization has, and then whether we can gel together as an organization. So lot, and especially the cross-border acquisition is much, much more difficult than a India-based acquisition or merger kind of situation.
Great. Here is a very important question from Ritika. She's I see that we have a lot of challenges regarding the copyrights today.
Corporate.
So how do copyrights? So how do
Copyright
protect their copyrights, and how can they avoid the infringements?
So typically copyright related aspect, Indian Copyright Act is, and I'm not expert on that copyright. You can actually suggest a few other intellectual property rights lawyers on this forum for sure. But whatever knowledge I have, so from copyright perspective, when you have created your own copyrightable materials, so to say, you own the copyright as such. It is not mandatory that we are required to register a copyright in India. So for example, software. Now software, if you go for a software code will change over a period of time. So even if you consider 3 years period of time, the whole code will be changed. So essentially you can claim the copyright, but do you need to register or not? I think you should seek advice from the intellectual property rights that how do you protect the copyright for a software product or something like that. But generally from protecting perspective, you need to have a non-disclosure agreement or confidentiality agreement, which includes certain elements. So if you're working with employees or you're working with consultants, you should have these kind of elements in the document. Confidentiality, non-compete, non-solicitation, and assignment of intellectual property rights. So whoever is working on the activity or outsourced project or as a consultant also, they are assigning the entire intellectual property right, be it copyright, patent, trademark, or any other intellectual property right that emerge out of that work. It is assigned to the employer or the company who is giving that work kind of.
Okay. Nitish's very important question. He wants to understand what are the most common pitfalls while negotiating contracts.
So the most common pitfall is negotiating from a weak position. That's the biggest worry. That the worry is that if I suggest certain changes to an agreement, does that mean that the client will go away or run away? No, it's just a proposition that you have given. So the client has provided certain terms and conditions, and without naming the clients, I would say that in certain cases, the clients also use templates at a large scale, and templates are used left, right, center. And some people just circulate the template without realizing whether it is apt or appropriate for this particular arrangement or not. But when you apply your logic and you say that, okay, by the way, this template seems to be not applicable to me, you can be very polite, but you can identify what's the logic there. And we have seen a lot of times the other legal team are forthcoming and they immediately understand the issue and they say, oh, by the way, what you have said is makes a lot of sense. This template doesn't appear to suit this kind of arrangement. We'll come back to you. So you have to be, you don't go in the negotiation with a weak position, but go with a complete confidence, with full of logic, and then you will be able to negotiate in most appropriate manner.
Great point, Alhad. Alhad, also one of the questions which is coming in multiple forms here and currently is also in terms of how do you actually make that entrepreneur understand the significance of contract as such. So people believe that if you can share some stories around it, that would help them resonate better within their own organizations or within their own peers.
Yeah, so 2-3 stories. So I'm going to tell you a story about one company into Catalyst. So they were into Catalyst is a very, very, very technically high-end product. So I learned first Catalyst in my childhood when chemistry, one of the unfavorite topic was out there, where what is the definition of catalyst, that this is the product, or this is something which is part of that reaction, chemical reaction or otherwise, which doesn't get changed into itself, but it changes the whole process. Either it can reduce the process or it can make different quality to the outcome or something like that. So again, Catalyst came to my life after some time with one company who were dealing into this kind of activity. And when they were making this Catalyst related documentation, we said that, okay, you're preparing one Catalyst for a company. Why don't you give a proposition, okay, that the other company is going to utilize these catalysts for X purpose, but there could be a Y purpose also. And if you have an opportunity to use the same catalyst for Y purpose, okay, you are ready to share revenue with the company. And this is what happens, because this brings a new business opportunity for the activity. So the proposition was given for the catalyst for A kind of procedure, and now here is a possibility of B kind of procedure, which the other which their client were not actually even contemplating about it. But because it was identified in the document and such opportunity came, both the companies were at a win-win situation. They got the revenue share because that kind of opportunity was there, and same catalyst with certain modifications was used. So those kind of things can be possible. Another example is about the change request. This is huge. Change request is a major issue, especially when you're talking about the software related industry, that you have delivered a product and somebody comes and says, oh, by the way, this light green color doesn't look great. It should be light purple. So it's as simple as a paintbrush and you change it. It doesn't work like that, because UI and UX, changing UI and UX is not a one-day job. It's a completely, so whole thought process changes. Maybe you can just say that, okay, the drop down should come from this side to this side or this side to this side, but then whole system architecture may have an effect about it. And it is not just a system architecture, but it will have functionality impact, logic impact. It can have aesthetics impact. So from a delivery perspective, there are multiple challenges. So ideas are popping up just like that, but translating into a delivery of a product or service, it's so difficult. And that's where if that kind of language is mentioned in the agreement, that if you make any change to the specifications than what you have agreed to, then it will amount to additional timelines, additional cost, and additional manpower efforts. And if that is done, then at least you from a vendor perspective as an MSME, you will be able to claim certain monetary gains for that. Otherwise, what will happen? You will delay on the project and the client will apply liquidated damages or penalties, which otherwise you should have earned certain additional money too. But if you have not mentioned that kind of language, you're gone.
Yes. Alhad, there is a very beautiful question which is there on the table. There, the question is that looking at the tech and the way the things are moving right now, and we have the whole chat GPT and everything coming around, right? So, a lot of information being available. So, how do you see this entire change in technology impacting the contracting way, or the way how you see this particular thing facilitating a better interaction between the legal aspect of it and the startup or the entrepreneurial part of it? How do you see both the sides getting benefited?
No, it's immense contribution by AI, and I'm sure that AI will contribute a lot to the legal field also, and especially when it comes to the contract drafting related aspects, it will make immense contribution. Number one, the best contribution that I've seen is that the flawless clause drafting of the clause with certain very good ideas or concepts that you have provided, and the kind of the representation that you get on paper is amazing, and that will help to speed up the work to a large extent for lawyers. And now it is the job of the lawyer to stitch together it in the most harmonious way. You can have a fantastic beautiful language coming out of one clause here and one clause there, but ultimately when a lawyer looks at the document, he or she looks at the document with complete thought process right from the beginning of the title of the document to the signature page, whether there is a common thread in the whole document or not. If the clauses are not in sync with each other, the document will look patchy and there will be a lot of issues. But then ultimately you can get a good clauses and good paragraphs from different sections. It needs to be put together with a logical mind and make sense. That whole document makes sense is the contribution of a lawyer. So it will reduce a lot of time and it will provide a very good quality, I'm sure.
Great. So building on this particular part, what are the few things that people need to see when they look at any contract?
So contract needs to be looked at. It's a reference document. It's a very good reference document. It brings clarity to the whole arrangement, and you need to get into details of operational aspects as well, and you can incorporate those operational aspects as well in the document, because it always becomes a reference point for future issues. So that one area you need to identify very clearly. The other 2-3 areas, I would say that look at the liquidated damages, which means that in case you have a delivery from a time perspective, let's just take an example of a project. So if that project needs to be delivered by, say, 25th of December, okay, and if you delay beyond that, then there is a liquidated damages after 25th of December for every day. Say 50 lakh rupees or 5 lakh rupees or 2 lakh rupees or whatever. So as a vendor, you should be aware about that. If I go beyond that timeline, what will be the loss that I'm going to incur, because the damages will be like an accepted damages, because it's a reasonable estimate of loss if I delay. And that's where the MSME person or party should provide additional things for safeguarding. For example, force majeure, which means if there is a situation like a corona kind of situation, or if there is a situation like agitations, or if there's a failure of some XYZ activity, those kind of things happen, then I should be able to claim additional time. It has impacted my work, I should be able to get additional time. So focus on those aspects. Penalty, liquidated damages, risk purchase clauses. These are the clauses which typically hit you in financial way. In terms of software related stuff, you may be aware about certain terms and conditions like UAT, user acceptance test. So you need to have a specification that user acceptance test should be done on certain predetermined parameters only, not because of any other parameters which I thought later on. Whatever parameters are there, laid down at the initial stage while developing the software, developing the system, then the UAT has to be done on the same principle, not any other thought. So those kind of things should be identified. A clause indemnity, clause related to limitation of liability, again, governing laws and dispute resolution. So you have to be very, very much aware about these kind of clauses.
There is a specific question which also talks about significance of confidentiality clause?
Oh, it's very important. Significance of, I'll give you an example of a research and development company. So research and development company, imagine the kind of research they do, whether it's a pharmaceutical, they may develop a formula or molecule over a period of say 5 to 6 years period of lot of hard work and multiple trial and error, and finally they find the real perfect match or perfect molecule. Imagine if the confidentiality is breached, the entire work of 4 to 5 years can be taken away from the company by somebody who's working in the organization, whether as an employee or as a consultant. And you can't hold the person back, or you can't penalize the person, or you can't go to the court also, because you have not protected your own confidentiality. So protection of confidential information is extremely crucial, and every document should definitely have that kind of reference. In some cases, it can be very elaborate clause. In some cases, it can be two-liner clause also. But then confidentiality is very important element in contract.
Alhad, I know it for sure, so that's why I'm bringing this topic specifically, is regarding your work with the whole technology companies, particularly on the online side. That's one aspect that I want to specifically bring out in this conversation. Because a lot of times, if you look at the multiple websites, the terms and conditions and terms of use and the policies are absolutely copy-paste, right? So irrespective of what you are doing. So why it's important for even the online portals to have these things sorted and properly prepared with somebody's guidance.
Right. So Indian mind works with Jugaad. So the best way to do that Jugaad is to go to the competitor's website, just copy paste terms and conditions, what are there, or a similar company, and just copy paste and use it on my portal. That's about it. And it's given to the website developer and said that, okay, these are the terms and conditions. Website developer says, okay, aapne jo diya hai, main upload kar deta hu, sort of. I'll tell you a funny story. So when I started working with an organization, so it was an initial meeting, and the person was into a very high luxury undergarments related portal, and I was not aware that there could be a dedicated portal only for undergarments related, and it was very premium kind of thing. And I said, okay, terms and conditions are required, blah blah blah, and he said, no, we have already copied certain terms and conditions. And I said, oh, interesting. Can I have a look at it? And then I looked at it, and then I asked him, sir, which kind of undergarments you use nuts and bolts? He said, what are you talking about it? How do you use nuts and bolts in undergarments? I said, that is what is mentioned in your terms and conditions, that you have given disclaimers related to the hinges and nuts and bolts and multiple other things related to furniture. Have you copied this terms and conditions from a furniture portal? He said, yes, we have copied that from a furniture portal. So that's the problem. So these are the things which usually, we have worked with so many different websites. So the recent one was related to purely about the pet related leashes and chains. Even I was not aware about that pet related leashes and chains. What could be a website? And yes, there is a website for that. And we have to get into a detailed study that, okay, even pets are allergic to certain materials. For example, fabric. They are allergic to certain the chains, and those kind of disclaimers are supposed to be given. If your pet is allergic to that, the pet parent should check all those aspects into the specifications of the product. So those kind of disclaimers are required. So every website will have certain unique challenges, unique problems, or unique risks which are required to be identified and declared, disclaimed, and provide all sorts of disclaimers which are possible with respect to that specific website as such.
Now I want to bring this conversation to the time where the individual or the MSME owners wants to realize the value that he has created for a year. Now typically this comes at two stages. One is that he is either looking at exiting that particular business by selling it to someone, or he is looking at an IPO, where he wants to bring in the public money and realize the value. In both the cases, the legal aspects play a huge role for the deals to go through, right? Can you please throw some light on this part? What happens in those conversations?
So when you're talking about IPO, there will be a detailed due diligence done by the merchant bankers. The merchant bankers, their attorneys, investors. So if there is a pre-investment, pre-IPO investments happening, so the people who are pre-IPO investors, they will be doing due diligence. And one of the very critical documentation which is looked at is all the contracts with respect to the all your customer related contracts. So I will split these kind of contracts into three parts. One is about the revenue side contracts, so which are all documents which are generating revenue for me. For example, it could be product related documentation, supply related documentation, services, AMC, or anything that generates revenue for me. Those are revenue documents. So whether those documents are very crystal clear or not, okay, whether and when you are working with even higher companies, there you have to be aware about certain revenue recognition conditions as well, that I may be able to book entire revenue. However, there could be possibility that although the revenue is booked, but it is not recognized because of accounting principles. So those kind of things are very critical and should be brought out in the documentation. Second aspect is about the operational related aspects. So first is the revenue related aspect. Second is about operational. The third part is about the your spend side. So vendors, service providers, your consultants, or any other people to whom you make the payments. So your understanding with them should be very clear. And again, these documents are vetted. And the second one is about the those who are going to bring the business. So channel partners, referral partners, implementation partners, distributors, franchisee, or whoever who is actually helping you to generate business. So all these three kind of documents should be in place in proper manner. It should be documented in physical. It should be documented in the digital mode. So at any point of time, you should be able to see the documents which are there and whether the documents are expired. A lot of times in due diligence, we have found that people come out with documents which are already expired 2-3 years back. They are billing, they are getting paid, but the documents are expired. And these kind of things can be crucial. The other element is about employee related aspects. Again, employee related documentation has to be precise. You need to have proper documentation available, employment agreement, NDA, all. So we have seen such funny situation that employment agreement is not signed by employee. In some cases, it is not signed by the management side as well, and the employee has been there on the roll for 2 to 3 years. ESOP documents. So those kind of documents are given and just shared just like that, without signatures, without any specific. And then when the dispute occurs, that's the area. So when IPO or these kind of critical deals are happening, these are the showstoppers of the deals.
Thank you so much for this great insights, Alhad. You were able to walk us right from the creation of the organization, the founders agreement, to the early stage contracts, to the growth contracts, to strategic partnerships, expansion going overseas, as well as meeting the other part, till finally the complete value realization in terms of sale or IPO. I believe everyone has enjoyed this conversation as I have, and I look forward to getting Alhad back with us again when we have a few more questions for all of us. If there are any other questions, I would wait for a minute, or else I'll let Alhad go and enjoy the Dhanteras evening with his team, and we will always pull Alhad back.
Sure. Looking forward to. Thank you, Charu.
Sure. So thank you so much, Alhad. In case of any questions, please drop in the chat itself, and I would urge Alhad to answer them during the Diwali or maybe just after Diwali. He would surely answer you. Thank you so much, Alhad, for your time. Wishing you and your team and all the viewers here, and also the team Thinkly, a very happy Diwali.
Thank you, Charu. Thank you, team Thinkly, and thanks, viewers. Have a very good, happy Diwali, safe Diwali, and prosperous New Year ahead. Thank you so much.